Good afternoon. The District Court of Appeal of the state of Florida and in for the Second District is now in session. The Honorable Daryl C. Casanueva, Judge presiding. Those having business before this court, draw near, give attention, and you will be heard. May God save the United States of America, the state of Florida, and this honorable court.
Good afternoon. My first instruction was to ask you to turn on your cameras, but I see that that's unnecessary, and I thank you. As everybody knows, I'm relatively technologically challenged, so I'm glad that we have you all here for this special remote oral argument by Zoom. I understand that the appellant will be dividing their time. I believe Attorney Tate will have 10 minutes and Attorney Hickman 5. Do I understand that correctly?
Yes, Your Honor.
Okay, reserving 5 for rebuttal.
Yes, Your Honor.
Okay, and I see that we have everybody present here on the case of Gene Tate Esquire and SAC versus COW. So we will proceed with the appellant's first argument at this time. Thank you.
Actually, Ms. Tate,
Yes,
before you get rolling, can I just ask a quick housekeeping question?
Sure.
You're here in your capacity right now as the attorney for the adoption entity, correct?
I am the adoption entity as well as the attorney for the adoption entity.
Okay, and the actual name of the adoption entity is?
Under Florida law, an attorney is an adoption entity. So
Okay,
it's
so
my name, Jeannie Tate.
Okay, personally, no ink or anything after that, or?
No, adoption
Okay.
entities have to be attorneys, not law firms. So
Okay,
it's Jeannie T. Tate, PA. I mean, I also represent the adoptive parents, but they're not technically parties to the case because of the confidentiality rules in Chapter 63.
okay, thank you.
Certainly.
I will let you know when you hit perhaps 9 minutes so that you have an idea that your 10-minute warning is about to happen. Because I understand after that, we're segueing over.
Thank you, Your Honor.
Okay, thank you. Please proceed.
May it please the court. Children, and especially 4.5-year-old Preston, who has been in the adoptive parents' exclusive custody since birth and still today, are in trouble if this decision stands. It is counter to decades of adoption jurisprudence, and there can be no greater need for permanency and stability in the law than in an area that involves permanency for children. This theme permeates Chapter 63 as recognized by the Florida Supreme Court in the JA decision. The trial court's refusal to analyze or follow 63062-2A, 63062-2A, that's critical, led to her erroneous legal conclusion that appellee's consent was not required to this adoption. This is a simple matter of statutory construction because 062-2A makes it abundantly clear that appellee has a standalone independent duty to provide reasonable and regular financial support to the child. He also has a separate standalone duty to either visit the child monthly or maintain regular communication with the child or the adoptive parents when he's unable to visit. This is unambiguous, as is 63053 subsection 2, which mandates strict compliance with these duties. And 63062-2E tells us exactly what happens because the appellee did not meet these duties. He waives and surrenders his rights to the child and his consent is not required. And that's exactly what happened here. Appellee admitted he did not comply with these obligations. He admitted he knew he had a duty to support this child from the moment of birth. And appellee cannot point to one place in this record that shows he met this duty or that he was prevented in any way from sending support. And his failure to send that financial support, that singular fact alone mandates reversal. He didn't do it in the 2-year period after the child was placed with the adoptive parents. And that means as a matter of law, as a matter of statutory interpretation, that his consent is not required. And we all have to follow the Florida Supreme Court decision in JA because it establishes that point without question. Appellee never even cites or addresses this dispositive and binding decision, which is the leading case in Florida on the consent required issue. In fact, the appellee's brief never addresses the failure to pay issue at all. And the trial court never made the required analysis under 062, instead determining that because appellee registered with the Ohio Putative Father Registry, that was tantamount. That meant that his consent was required. She makes that finding in the record at 1995-96. That conclusion, that legal conclusion, is 100% in conflict with the Florida Supreme Court decision in JA and cannot stand. The trial court also confused the consent required issue under 062 with the separate second independent analysis of abandonment under 63-089, and that was the fundamental predicate for her error. And juxtaposed over all of this is the fact that the court was required to determine the appellee's status at the time our case was filed, when Preston was almost 2 years old. That is statutorily mandated by 062-1B5. And at that time, appellee had done virtually nothing vis-a-vis the child. The trial court instead erroneously relied on what appellee did after he was served with this suit, and did that to excuse the fatal deficiencies that existed at the time this suit was filed. Appellee's brief never addresses that determinative time frame and that mandate from the legislator about when we need to measure the father's status. A second standalone independent reason that reversal is required is because the appellee did not communicate with the child or the adoptive parents in almost the 2-year period following placement. This means, again, as a matter of undisputed statutory construction and interpretation, that his consent was not required. The facts were not disputed on this point. In fact, the undisputed evidence at the time this suit was filed was that, one, the appellee never ever tried to communicate with the child, never ever tried to communicate with the adoptive parents, although he knew their names, he knew where they lived, and he knew how to communicate with them. He testified he wanted nothing to do with them. He did not speak to them by his own choice and had absolutely no intention of contacting them. That was his testimony. He told the adoptive parents that it was unacceptable for them to try to communicate with him. He admitted he could have contacted the adoptive parents and the child if he wanted to do so, but he didn't want any information about the child and didn't need any information about the child until the child was with him. Appellee admitted that he purposely, his words, purposely lied under oath on multiple occasions in the trial court proceedings below in his answers to interrogatories about his address because he didn't want the adoptive parents to know where he was. And although the trial court minimized that egregious admitted perjury, it was relevant to a breadbasket issue in this case, which is the duty to communicate. So when the adoptive parents reached out to communicate with him, and they sent him pictures, gads of pictures, letters, and updates about the child, he didn't receive them because he had lied about his address. And he never, ever, despite the misstatement in the appellee's brief, filed a motion for visitation in either Ohio or Florida, and never, ever sought contact with this child again until after this suit was initiated. And 63-062-2E tells us exactly what happens when he doesn't communicate. He waives and surrenders his rights to the child and his consent, is not required. And similarly, that status is determined at the time our case was filed. Now, the trial court was troubled that this case was filed in Florida. But where a case is filed is dictated by subject matter jurisdiction, not by the parties. There's no legal hijinks in a subject matter jurisdiction analysis because, as this court well knows, you don't create subject matter jurisdiction by agreement. The mother lived in Florida at the time of conception. The mother lived in Florida almost, well, the vast majority of her pregnancy. The mother lived in Florida the vast majority of this child's life, all of which was known to the appellee. She didn't hide out. She didn't lie about her pregnancy. Ohio determined that it had no subject matter jurisdiction after the Ohio Supreme Court ruled because the father hadn't been there in 4 years. The mother hadn't been there in a year. And other than the fortuitous place of his birth, the child had never lived there. Florida, our trial judge also found that Florida had subject matter jurisdiction over this matter.
You're at 9.
Oh, boy, that goes fast.
Yes.
Let me talk for a minute about the fact that even if Ohio law had applied, it wouldn't have made a difference because Ohio law imposes a duty on the appellee to financially support the child, as does every state in this nation. And the VRK case, which is Ohio law, a case that was ignored by the trial court despite its binding nature here, if Ohio law is looked at, the father had several weeks to act and support the child, but he didn't pay any expenses for the child. He didn't pay the mother's expenses. And because of that, the Ohio court determined that he had no rights to the child and he therefore was not required to consent. The Ohio court specifically stated that his offers to assist didn't matter because he didn't actually provide support. And
That's past 10.
in that case, just take 30 more seconds, Ms. Hickman.
It's not my time.
The mother actually blocked the father from communicating with her and didn't respond to his messages, and he objected to the adoption before birth. That sounds exactly like the case we have before us, and the Ohio court said his rights are extinguished because he didn't support the child. Thank you.
Thank you, counsel. Go ahead if you wish at this time. Attorney Hickman? Mike?
I'm sorry, I'm having trouble with my mic. May it please the court, my name is Amy Hickman, and I represent the biological mother, Sarah Chapman.
And Attorney Hickman, I am going to give you your 5. What I will do is extend the appellee's time by the extra 30 seconds.
Thank
So
you.
you're not going to get subtracted.
Okay. Thank you. The most significant time period in this case is the time period when my client made her decision to place her child for adoption in the state of Florida. That decision was highly criticized by the trial court and the appellee, and it was wrongly criticized. A big part of this criticism was based on the fact that the issue was heavily litigated in Ohio, and therefore the mother wrongfully made the choice to subsequently place the child in Florida as some type of maneuver to avoid Ohio law. It is Ms. Tate stated that there is inequality between Ohio and Florida law. A review of the Ohio Supreme Court decision in this case was highly instructive to the biological mother and what action she needed to take after the Ohio Supreme Court decision came down. Because the Ohio Supreme Court decision made a very clear distinction of what an unmarried biological father's responsibilities are to an unwed mother and to a child. And that clear distinction is that the father had a responsibility to provide financial and emotional support to the child after the child's birth. The decision in the Ohio Supreme Court declined to apply the financial requirement to the pre-birth responsibilities. And it was very clear throughout the Ohio Supreme Court decision that the court did not rule, because there was no cross appeal, on the very small claim of post-birth abandonment in Ohio. And that claim was literally a 3-day claim that the father had abandoned the child between the child's date of birth on November 3rd, 2015, through the date that my client placed the child for adoption in Ohio, November 6th, 2015. So the Ohio case was very instructive, and my client was left with the facts of the case, which are undisputed, that since November 6, 2015, the appellee took no action to visit the child other than one a hallway request to visit the child. There was no request for visitation. And the father paid only $100 in financial support that he admits in the record was only token support to support his case. And it wasn't meaningful support. Understanding that and faced with her constitutional right and responsibility to make a best interest and welfare decision for her child, she chose to place her child for adoption in Florida. And Ohio law is clear. It's not an abandonment issue. It's a whether his consent was required issue. Did he provide financial and emotional support for the child? That is absolutely consistent with Florida law and the construction of Florida statutes, which says once a father registers with the putative father registry, he must also comply with the responsibilities in 63062(1)A, which the father did not do. And so at the time that the biological mother signed her consent for adoption, her adoption placement was consistent with the clear law of Ohio and of Florida. The problematic concern as to whether or not subsequent litigation would bar the mother's right to place the child for adoption, even though the father did nothing to provide for the child, was of concern for the court and summarily disregarded. And that was a wrong conclusion.
At 4.
Thank you, Your Honor. The VRK case is instructive on that litigation does not toll a father's responsibility to provide for their child. And the JCJ case in Florida, decided by this court, and the Home at Last case, decided by the 5th, are very, very clear. And all of those decisions are consistent with the Florida Supreme Court's decision in Doe, which says the evaluation of a child's welfare is a continuum. The father would have this court rule, as the trial court did, that the judgment terminating his parental rights in Ohio gave him some type of immunity from supporting the child. That summarily ignores the child's interest and the directive in Doe that we are supposed to follow the continuum of the child and look at what the societal norms are. And completely and summarily disregarding this child would be a whole violation of the ruling in Doe, as well as a parent's societal norms to provide for their child.
You have gone past 5.
Thank you, Your Honor.
Thank you, counsel. Give me a chance here to adjust the clock, and then we will go to the appellee's argument. Counsel, you would have the 20 plus 30 seconds, and I will let you know when you get to 15.
Thank you, Your Honor. Everyone hear me?
Yes.
Thank you so much, Justices. I appreciate doing this. I've never done it on Zoom. It's all a first experience for all of us. I want everyone to review that these situations are horrific all the way around. They are emotional for all the parties. Hopefully the child is the only one that we are all focusing on and considering, which we all are. In that regard, the trial judge did not take this case in a vacuum. It didn't just begin when the petition for termination of parental rights was filed in Florida. This case has begun since even pre-birth. And whereas opposed to VRK, the Ohio case, which appellants cite, that father did absolutely nothing, even though he knew what was going on and didn't proceed anything. This biological father filed with the putative father registry in Ohio before the child was born. Florida statutes say that If you're from another state, comply with the requirements of your other state, which is what he did. He filed with the Punitive Father Registry in Ohio, filed a paternity action in Ohio. He didn't know when the child was born. They didn't tell him. Nobody told him when the child was born. He learned on Facebook or social media, and then filed after that for paternity. And then he followed all the way through the Ohio Supreme Court, which came down with his decision that basically said he complied with everything in the Ohio statute, that his consent is required. And that, understand, we know that we do use these punitive fathers must step up to the plate and announce themselves and put themselves forward and not show a manifest intent to disregard those, but to step up. This gentleman did that and continued to do that. Paying child support is one issue, one factor to be considered, but it is not the exclusive factor at all. As the Ohio Supreme Court said, just failure to pay in and of itself is not enough. Was there a request? Was there a refusal? Was there a need? In the Doe case, which I was there in 1989, I can tell you that mother was destitute, begged the father for assistance, and the father just simply ignored and refused. In our case, the problem here is that the birth mother did not seek the father's assistance and input and help, and then because he didn't help, she then focused on adoption. When she called him to tell him that he was going to be a father, in that same conversation, she told him he wasn't not going to be a father because she had already planned to put the baby up for adoption. I also want to take us to the Florida case of JCJ, which is JCJ versus Heart of Adoptions, which again, Ms. Tate and I represented the adoptive parents on that one. We offered the father to come and visit with the adoptive parents, come and visit with the child. No such offers were made here. In fact, the only communication from the prospective adoptive father to the biological father was using a fictitious name. And again, it was only for the purpose of trying to convince him. In the JCJ case, the significance of that case is that we are evidentiary. We are to look at what he does, not just when the pleadings have been filed, but throughout the entire case, all the way through up to trial. And that's what JCJ said after a reversal on the appeal, came back for the trial court. Yes, he filed. Yes, he hired a lawyer, but he didn't do anything for the child or support the child. Appellants want to take a narrow time frame. And this is in the time frame after the trial court and appellate court terminated his rights. And at the time of the Supreme Court, where all of the jurisdiction is in Ohio, and then he won. Now he's expecting the child to come to him. So would he send child support payments to those prospective couples that's now supposed to give him the child? What he did was spend money to set up his nursery, to take care of the child that he thought was coming to him. And again, I say this is all in totality, because what you look at what he did when the action was finally filed in Florida, he started paying child support in a repetitive, customary manner every month, and still hasn't missed a month of child support to this day. He sent birthday presents. He sent Christmas presents. He didn't send a Christmas present for December, I think, of 18, only because he was supposed to have a visit with the child and was going to give him the present specifically. That visit got canceled because the child of the prospective adoptive parents' other child was extremely sick and in the hospital. Very, very delicate situation. Very sympathies to all of them for all of that. But nevertheless, he did. Plus, the evidence shows that he spent over $3,000 just to see the child for a couple of hours. Remember, he is in Michigan. The child is in Tennessee. The transition specialist is in Florida. The mother's in Florida. He has to travel all over, and he did this and is paying. So to look at this from the trial judge's point of view, is his consent necessary? And they viewed, yes, it is. He has been intently trying to take care of this child and intensely try. As the court said in the VPK case, they said they were not impressed at all with the biological father. He wasn't sincere in wanting the child. He thought he wanted the child only for his mother, or that when he thought they were going to come after him for abandonment, then he wanted. But in our case, the trial judge said, this is a man who truly wants to parent. He desperately wants to parent his child. There's no action he did or omission that would amount to a substantial show, the manifest that he intends to willfully disregard his obligations as a parent. This man has done everything possible to be a parent. Yes, they're right. There's some times when child support wasn't paid to the prospective adoptive parents. Yes, there were not phone calls to the infant child that he wouldn't be able to speak to the infant child anyway. And there was no communication. Again, I'm going to blame the lawyers, I guess, for not facilitating communication. When this case came to Florida, Ms. Tate and I did work together in trying to get some communication between these people. But again, I'm going to say they fault the father for not filing a motion for visitation. I've been on both sides of this equation for 4 decades now. And I can tell you that when a punitive father files a motion for visitation, it's always denied because he has never reached the status of a parent until the court orders it. So you're not entitled to visitation. But certainly in how this thing works, how these adoptions work with the child in another state, the biological father in another state, the biological mother in another state, they're not talking. He did everything he could. As you read the trial court opinion, the standard of review is abuse of discretion. It should not be a de novo proceedings. It's abuse of discretion. Even EAW says we don't put down specific directives for the child. This is all on a case of fact-based case, fact-driven. What did they do during the pregnancy? What did the father know during the pregnancy? What did they do? It's all fact-driven, and it is all discretionary. The mother's attorney argues that you should judge the credibility of the witnesses. Well, that's not permissible. The trial judge is the one that judges the credibility of the witnesses. The trial judge is the one that's there to look at everyone. And every decision the trial court made, she put a finding in there. There were credibility issues. Did he tell her to get an abortion? No. He simply asked, have you considered all of your options? This is the kind of thing that the judge had to make decisions about. The judge's 31-page opinion is specific, detailed findings. Yes, the best interest of the child permeates all adoptions, but as Doe says, as EAW says, and as of HOA says, you don't get to best interest until you finally get to abandonment. It's not a best interest test. These are not people of equal parentage, the adoptive parents versus the biological father. The biological father is entitled to be able to raise his child if he exercises that right, exercises that inchoate right, which is exactly what this man did all the way through the Ohio Supreme Court. And then imagine his deflation when he thought he had won and was going to speak to the adoptive parents about transition, which, by the way, we recognize transition is difficult. We have yet to push transition. We are working on establishing a bond between the biological father and the minor child, but we understand how difficult this transition is. It's not always to say the best interest of the child is always to stay with the adoptive parents because they're two parents, they've raised the child. It may very well be that the ultimate long-term best interest of this child would be to be with his parents, biological parents, who love him very, very, very much. I also would like to be able to continue to argue that this man is continuing in his fight for his child. The record is replete with the expenses of payments and monies and legal and challenges. And I have to say that the system failed all of these people. My client, Appley, filed 2 paternity actions, not 1, two paternity actions in Ohio. The first one should have been parked. Instead, it is the petitioners, it is the appellants that move to dismiss it. Had that a paternity case been parked, we would never be in Florida. It would have stayed in Ohio. And then unfortunately, when he filed his second paternity action in Ohio, nobody was there. They couldn't connect it to the first paternity action, and they dismissed it because no one resided in Ohio anymore. It's truly a sad state of affairs for this man to try to find. Then from there, what the trial court did in adjudicating him to be dad, and says it, no one else did it. I have to say, your justices, that the Ohio Supreme Court kind of failed everyone here without giving directions. The only direction they gave was to dismiss the adoption, but they didn't give any direction of how to proceed forward. That gave latitude for the adoptive parents and for the birth mother, as I said in trial, connived, conspired, and confederated to get together to seek out additional source of jurisdiction to be able to countervene the Ohio Supreme Court's decision. And that's exactly what they did by filing this action in Florida. Now it's 20 months later. So under the Florida statute, because it's a child over 6 months, my client did not get a notice of intended adoption plan, giving him 30 days to comply, file with the registry, pay support, say, and then he would have done all of that. But because the child is over 6 months old, he doesn't get the notice of intended adoption plan. But he still filed with the punitive father registry in Ohio and fought at the trial, at the appellate level, and at the Supreme Court level for his child. Once this case now comes to Florida, he starts paying child support in a regular way, in a repetitive, customary manner, every month, and they want you to look at only a time frame when jurisdiction was in Ohio. I say you have to look at the totality. I and JCJ says you have to look at the totality of the circumstances all the way through and up to the day of trial. How much time do I have?
You were at 13 plus a half. Heading
Well,
towards 14.
I'm open for questions from any of the justices.
I'm not trying to be humorous, but they're all in Tallahassee. We're only judges.
Oh,
But I thank you for the compliment.
I know I can just continue, but these are heart-wrenching cases, and they shouldn't be decided necessarily just because the adoptive parents are more stable, if they're more stable, that they're married, if that makes that big of a difference. Families these days are all kinds of interwoven. My client is ready, willing, and able to raise and take care of this child with the biological mother, should she choose to do that or not. On the issue of the court reserving jurisdiction, the Florida statute specifically says if the petition for termination of parental rights is denied, the judge must fashion something. And that's what the judge did. She said a transition specialist, which is what the Ohio Supreme Court did not do. And then with that transition specialist, she set up enforcement proceedings. Should we need to come back for enforcement proceedings? I will say that no one has had to do that, that everyone has been cooperative in trying to introduce the child to the biological father and the biological mother. The logistics have been insurmountable sometimes, and sometimes cost prohibitive, but all parties have been doing that. The judge then did say something that is concerning as to whether or not she holds jurisdiction for all other matters. I filed a paternity action in her court, and that has been venue transferred to the venue where the biological mother lives. So it's just really a non-issue. I will say we have a problem because now we have two courts, one in Hillsborough County and one in Osceola County, that both have jurisdiction over this child. It may be corrected once we get moving forward in the paternity case, but as far as what the judge did in the adoption case is absolutely correct pursuant to statute. start a transition specialist, work on how we handle this now that the judge has made this ruling that the adoption cannot go forward. You cannot fault the judge for that. All of the findings she had were specific and specifically mentioned credibility. She was able to see the demeanor of all of the witnesses. And she was able to view all of this. This is not a decision made in a vacuum. This case did not start when the initial petition was filed by Ms. Tate in Florida. This case started before the minor child was born and continued all the way through Ohio Supreme Court and now in Florida. And to say that my client has no interest in the child, has manifestly showed that he is willfully abandoned. Look at the content of the record. Look at what he has spent to visit with this child, what he has done, all the hoops he jumped through to get psychological testing, to get psychological evaluation, to meet on a supervised visitation for only a few hours. She tells you how desperately this man chooses to parent his child. And that cannot in any way be viewed as abandonment. I think I've said enough. Thank you all.
Very well. Thank you, counsel. And we have the rebuttal time remaining of 5 minutes, and the appellant may proceed.
Thank you, Your Honor. Apolli did win in Ohio, but Apolli stipulated that that win had absolutely nothing to do with his post-placement abandonment or the need for his post-placement consent, which were proper subjects of this action. And I disagree with opposing counsel that you have to look at the totality of the circumstances in deciding the consent required issue. The statute very clearly tells us that that ball drops at the time the TPR is filed. And that's when you have to look at what this father did, not in the courtroom, but to the child. The fact that Mr. Marchese bolstered him up to start sending support or start asking for contact for the child does not erase the immutable deadline that is placed in the statute. The facts, the material facts, were not really in dispute in this case, as the trial court herself recognized. And the Florida Supreme Court has taught us that adoption exists solely by virtue of statute, and the trial court's decision must be grounded in the statute. And her failure to follow 062-2 requires reversal, because the father's consent was not required because he did not provide any support to this child other than a token $100 in almost 2 years. The decision below is contrary to every leading adoption decision in our state. JA, JCJ, Home at Last. JCJ, a decision of this court, the trial court wrongly distinguished because JCJ, just like Apolli, litigated for 4 years, litigated and litigated and litigated, and also filed a paternity action, but it was insufficient to preserve his rights because he did not financially support the child and he did not communicate with the child. And Mr. Marchese wants to talk about how his client stepped up. He stepped up, perhaps, if at all, in litigation. And litigation as a matter of law is insufficient to excuse parental failures. And while the trial court harshly criticized the appellants for seeking the benefit of legal counsel and successfully prosecuting certain positions in litigation, she praised the appellee's extensive litigation efforts and wrongly allowed his litigation to satisfy his duties to the child. That's contrary to JCJ, that's contrary to Home at Last, and it's contrary to 63032, which requires the court to look at his efforts towards the child. Her words, her conclusion that epic legal battles meet parental responsibilities and excuse his non-performance is unsupportable and requires reversal. And of course, why is that? It makes no sense from the child's perspective. The child doesn't eat or have a roof over his head or clothes on his back because adults are litigating in the courtroom. It is troubling that the court made the legal conclusion that the appellants prevented the appellee from complying with his parental duties because there was no evidence to support that. She made no factual finding because there was no evidence that the appellee was prevented from sending support. He admitted he wasn't prevented from sending support. And how could he? He sent support in December of 2015 and never did thereafter. He also admitted that no one prevented him from communicating with the adoptive parents. That was his call. So under the undisputed facts and the law that we must follow in 062, this court must reverse. I think the trial court was confused because she shifted the burdens that the appellee has to the appellants. There's no statutory or case law authority to do that. And in fact, that burden shifting is prohibited by 63063. It's replete with references to the father's duty to act, the father's duty to step up. There is absolutely no requirement in statute or case law that requires the appellants to ask him for support, to inform a represented father of his support obligations, to outline specific medical or living expenses, although they did, or invite a hostile birth father to their home. And they don't have to provide receipts either, as argued by appellee, even though he never requested those until after Preston was born and placed with the adoptive parents. We should all lament multi-jurisdictional adoption disputes that languish too long. That's the reason we have clear, bright line adoption statutes that provide predictable short-term outcomes for children. That's exactly what 63062 is designed to do. And the crux of this
you
case.
to sum up quickly because we're past 5. So I'll give you another 30 seconds to sum up if you would.
Okay. The crux of this case is what the appellee did prior to the filing of this suit and prior to the child's placement. This case should be reversed with a very simple opinion that appellee's consent is not required because he did not provide a reasonable or fair amount of support for the child in almost 2 years following his placement. Thank you, Your Honors.
Thank you all. Thank you for a very fine presentation. Please stay well and safe. I think I'm to ask you to somehow disengage or withdraw, to close your camera, whatever at this point. There's nothing coming on afterwards. Normally we say you can go to the next stop and watch moral arguments, but you're the only case on the docket today. So thank you very much.
Thank you.